Rob, welcome to New Jersey.
Thank
We
you.
have a lot going on here in New Jersey. But it was just only a few years ago that we met at NARPA in Newark, New Jersey. So tell us just briefly, what is NARPA and why did you elect to actually do a keynote there at NARPA?
Well, they invited me, so that was great. But I've been aware of NARPA for some years, the National Association for Rights Protection and Advocacy. So these are lawyers. It's an interesting history. I don't know the details of it all, but in their history, they sort of split off originally from the National Disability Rights Network, which is the mainstream organization that has all the main attorneys in America that are funded by the federal government in the protection and advocacy sphere. And the people that are in NARPA felt that it just wasn't strong enough, particularly in the mental health arena with respect to involuntary commitment and so on. And so this is my understanding. It happened a long time ago. And so they kind of splintered off just to kind of create a group that was more focused on a stronger approach to those kinds of issues. I understand that there's a little more working together between those groups now, again, which is great. But in any case, they've kept NARPA going, and it's the kind of conference. Mainly, that's what they do is organize a conference each year, and it brings some of the lawyers that really care about these issues, that are really passionate about the civil rights of people who are getting detained and locked up in the psychiatric system, and want to share knowledge. And so, for me, I'd been to a few of the conferences and loved them. And it was great to be able to come there and speak myself.
Well, it got our New Jersey team there to meet you, and that's just kind of expedited a lot of our work in New Jersey ever since. So thanks for coming back again. You and I and many others, we also show up on the virtual mental health advocacy group that came out of that NARPA conference. What do you see happening on that? It is a lot of lawyers, might be mostly lawyers, but it's some of us with lived experience, or you as a journalist, an author. I don't know, what's the purpose of that online group, and what are you getting out of it?
Yeah, I think it's great development. I think any level of national organization that can take place on these issues is really important. There's a desperate lack of that. Really at almost any level in terms of the issues around involuntary commitment and civil rights of psychiatric patients directly on that issue. So it's great to see that development, that some of the legal people involved with NARPA have found, understood that that gap exists as well, and have made efforts to kind of bring more people together. They're opening it up, inviting other people on there, and trying to move the needle on some of these issues. So they already created sort of separate committees that are looking at specific issues, and those people are kind of talking and saying, what could we do? How can we move this? And they're not focused only on their own state. Which, of course, with law is understandable that people do, but in this case, they're trying to say, okay, what would apply across the country? So I think that's really great.
I've noticed that there's conversation across New York to New Jersey to Massachusetts. Maybe California steps in, and there is a sharing of this is going on in our state and what's going on in your state, and then there's also a sharing of information, so that if a law is enacted one place and it's not yet in another, I don't know, it just seems like it's a coalition of lawyers or advocates.
Yeah, I don't know if we're there yet for them to be really, calling them a coalition, but it's a communication, a conference or something online happening that has that promise, right? It's the promise of a coalition I think we're seeing right now. But yeah, it's great. It's, I think, very promising, and we'll see where it goes. These kinds of groups are easy to start sometimes and harder to really sustain. What can we do together? What's available? But at the very least, that sharing of information. For example, since the book came out, I've probably been contacted by people working in these areas in 10 states myself saying, what information do you have on assisted outpatient treatment or involuntary outpatient commitment? And because they're battling that out with legislators in their state, and they're not all connected and communicating, you think, hey, a lot of the arguments are going to be fundamentally the same. Everybody should be sharing, their research and their main talking points and so on, and kind of sharing that. And so that I think that will happen through a group like this. That's really promising.
It's the part that excites me the most. Litigation, lawsuits, psychiatric rights, civil rights, legal rights in the home mental health system. As you probably know, in 2005 I was put in involuntary to the hospital, and I did not know my psychiatric rights. I did not know I would have a right to a hearing, not a clue. So could you just give us some of the background of when someone is involuntarily committed, what are the rights?
Yeah, well, I got to say, unfortunately, what you just said is completely common. Many people have no idea what their rights are in these kind of situations, and they're not told. And of course, when I present this to psychiatrists, administrators at hospitals, they often say, well, they were, losing their minds. How could you trust them? But then we can find it's just verified over and over again. Independent studies have been done on this to show that it's routine, that not only even though the law is very clear in every jurisdiction, there's always some sort of notification a patient is supposed to get of, here's what's happening to you, here are the relevant laws it connects to, here are your rights. They're supposed to have contact phone numbers for lawyers. It lays it out. And in every state that I've ever seen, in every province in Canada as well, it's routine. It's written into the law. And yet, we still to this day find every time an independent study of this has been done by, for example, an ombudsperson, so they'll come in and they'll look at all the records and they'll find that it's routine for these hospitals and doctors, medical staff, to break the law, to not do this, to not fill out the forms, to not get you to sign. You're supposed to usually sign a form that says, I know I've been told this. There's even a clause there that says, well, if the patient is not able to understand, what then? So they can sign it in lieu of you signing it, but you're always supposed to be offered it, and all that. They should have your signature somewhere, right? All these things. So they're routinely not done. And when I say routinely, I mean usually it's the majority of cases. So studies have been done that show, yes, like somewhere around 3/4 of people are not either they're not told their rights, or just the forms are incomplete, or the diagnoses aren't even done. So people are often locked up with no mental health diagnoses, or just the criteria in the law are not completed. So it's not clear, was the person supposedly a danger to themselves or others? What were the criteria? How did you assess that? All this is supposed to be done under the law, and it rarely is. And so this is huge, right? Because we've created these laws that are so broad, give so much flexibility to the medical staff to exert control and take away people's rights. And yet even then, they routinely overstep those bounds, and there's very little regulatory control over that, very little enforcement of that. You'll rarely see a doctor getting in trouble. The only time I'll see this play out is in a court case. When it lands in a hearing, judges don't like it. So if you've got a good enough lawyer, and all it really takes is for them to ask you, did you sign a form? Usually people do have. It's remarkable how accurate people's memories are, I find, for this. Whether they signed a form, what they were told or not told, it's quite the opposite of the kind of conventional narrative. Oh, people are so out of it, they don't know. I find often what they say it can be really verified well. And so when a decent lawyer asks these basic questions, goes to get the medical records themselves and looks in, they often then can just go to a judge and go, look, this form was backdated, they clearly didn't fill it out in the appropriate time frame, notification wasn't signed, this, that, and the other. And judges often get irate about it because, that's what they're supposed to be doing, is upholding the law. So I've seen people definitely get let off, get freedom during their hearing on technicalities of that kind. At that point, it's not even an issue anymore. What was the real issue and how, and so on. It's just entirely like, you've got to at least follow the law here. But again, a lot of lawyers actually don't do that. So that's another problem, because they either are very biased against their own clients, or they don't know to look. They're not well trained in mental health law themselves. So we see this. And again, I'm not just saying that from my own research. We have some studies that have looked at this. You know, an ordinary public defender doesn't have training often in mental health law, so they don't know the ins and outs of this. And so it really comes down to, do they train themselves? Do they learn it? Do they become a real advocate for their client? Or are they just kind of rubber stamping it because they're being paid very little? Often they don't make a lot of money as a public defender, and so they may just let it go, you know, and then as the client, as the patient, you're just kind of on your own.
So let's talk about the two different stages in my mind. You know, a hospital hearing, somebody is locked up, you know, against their will, and there's a hospital hearing, and then other people, they manage to get out and might launch a lawsuit. In my scenario, again, I didn't know my rights, but I was completely coherent. In my medical report, it said cognition intact. What does that mean? Cognition intact.
Yeah, that usually means that you were coming off very well, that you seemed lucid, you seemed intelligent, you were polite, you were respectful, diplomatic. That's usually what cognition intact means in my understanding of how they use it, and usually in the medical records when you're parsing out the different elements. Yeah, that's typically what it means. The person was actually, you know, it means that you were probably seeming pretty normal to them in that sense, normal, quote unquote, right?
Yes. We'll see if we go into my story later tonight, because again, there were presuppositions about a previous diagnosis 25 years before that also then got tagged. So I was treated from a previous diagnosis, but they also said cognition intact. Mm-hmm. So we'll get back to that.
Yeah.
So I was well aware of my rights were not met. Read. I had no clue that you even have a right to have a lawyer or anything. So let's talk about the hospital hearing. What is the general guideline or rights of someone to a hospital hearing?
So it varies a lot from jurisdiction to jurisdiction, of course, but what I tried to do in the book, and generally when I talk about this, is to look at it in a general way, what really happens. And so, for example, even before we get to hearing, and it's important for people to know that, you can be locked up in most jurisdictions for anywhere from a day to a few days, up to several weeks. There's a couple places where it's even over a month, without a hearing. So you have no recourse. Essentially, you're being detained for evaluation purposes. These are emergency detention laws, and these are actually the most common ways in which people are detained under mental health laws in North America, using that power that exists. So you don't get a hearing at all. You don't get any opportunity to present your case. And in some of these jurisdictions, during that time, you can actually be forcibly drugged, forcibly treated in some way. Usually that's for emergency purposes. They can do it at any time. Some even allow it sort of for routine purposes. And again, the law gets bent and broken all over the place on this. But at some point in every jurisdiction, you do get an opportunity for a hearing. In America, it's usually in front of a judge. In Canada and in some jurisdictions in America, it will be in front of not really a judge, something less than a judge, a different kind of court setting, or even a tribunal, where they're just appointed people by the state who have that kind of authority vested in them. So at this hearing, they're remarkably quick, frighteningly quick, we might say, in most cases. And by that I mean here are all your rights hanging in the balance. You could potentially be forcibly drugged, even electroshocked against your will in this kind of setting. So very extremely important moment in people's lives. And these hearings often can be 20 minutes long, 30 minutes long. I've seen them go hours, for sure. Usually that's because somebody really had the resources and tenacity to hire maybe even a private lawyer to go along with a public defender, and they really went through the records, and there was preparation time spent. So it can happen, but often they're quite short and brief. And essentially, the question is just your level of competence to make decisions. That's typically what's at issue in a hearing. Do you have the ability, in the eyes of the court, to decide whether or not you understand what troubles are going on, and what the options are, and what the recommended treatments are, and what the pros and cons of those might be for you. And if you're capable of understanding that, under the law, you're supposed to be allowed the right to refuse. But in fact, that isn't how it usually plays out.
No. Tell us, in your book, you do write about a young woman about 10 years ago. She was 24, 25. We'll say her first name, Sarah. And tell us about her story, because she had a hearing. And just give us a little bit of how that went about and what was the result of it.
Well, yeah, in her story, she had been, had more than a couple of detentions, and decided to finally challenge it. And I think, she describes it well herself as that realization that you and I are talking about now of, wow, I was just looking for help, or I was just struggling, and now suddenly my life is hanging in the balance. All of my rights, how can this be? What crime did I commit? The crime of just being in a bit of distress, and struggling in that context. And so, yeah, I felt a lot of understanding and empathy for her and that story. And I don't know if it's not my place to I wasn't there to describe the blow by blow, so I don't know in particular what you'd like me to comment on with that.
Well, from reading your book, I remember part of the story is I think she was wheeled out on a gurney to the hospital court.
Really? No, I didn't know that.
Okay, maybe I picked that up.
Yeah, from her.
But what I understand is she actually had a hearing while she was in
the hospital. So this is very common.
Yeah.
So, okay, I'll comment on that. So yeah, it's very common for the hearings actually to be in a hospital setting. And not only that, this is obviously very prejudicial, because in some cases then you're still left in your hospital scrubs, the setting is also very implicitly threatening, because you've been struggling against the threats already in that setting. You can be actually being drugged against your will while it's playing out. I've seen people dozing off in the middle of their own hearings, not because they wanted to, because they were so heavily drugged. So yeah, this setting is incredibly prejudicial. And we've had that play out in prison context, in the criminal justice system, where they've said, okay, you need to allow a prisoner to get their own clothes back, perhaps dress up for a hearing, go to an actual courtroom, and so on. You can't have them in the jail cell in their jumpsuits. It's just too prejudicial in the eyes of the court, right? It's hard for anyone to get beyond that kind of a prejudice. We don't have that kind of enlightenment yet happening within the mental health sphere, unfortunately. There's this very heavy mix of paternalism and aggression, really, and prejudice, all playing out simultaneously, where, well, we're doing this for your own good, so nothing matters. It's a strange logic that's working there.
And what was the result of that? The hospital hearing that actually resulted in her release. And again, I don't know if you even had the details in the book, and I'm confusing having the conversation, but that was successful, as I understand it, and she was released.
Yeah.
So that's a good news.
Well, yeah, and in that case, as I understand it, it was simply that the lawyer, and in that state, they have some specially trained lawyers that do the commitment hearings, and that lawyer forced the doctor to address the actual issue before the court, which is what the law is supposed to be about, which was, is this person truly dangerous? And the psychiatrist kept insisting, well, we've labeled her with bipolar, that's not how they say it, of course. They diagnosed her with bipolar. Bipolar people are generally more threatening or violent. He was reverting to these gross generalizations, and then was challenged on that by the lawyer to say, yeah, but we're not talking about bipolar people in general. We're talking about this person here. Do you have any actual evidence that she's in some way a danger? And the answer was no. And so she got let go. And that should be happening in all these hearings. Many lawyers have told me that they feel that less than 5% of their clients typically meet the actual legal criteria as laid out by the Supreme Court in the United States, that you need to be really, really threatening and dangerous to others in order to be committed. And very few people actually meet those criteria.
I'd like to come back to that in a little bit when we talk about media, because I would say most of us do not know that of how hard it is to prove that statement. You have to be in danger of self and others. Most people kind of know that statement, but the fact that there's lawyers who are saying very few even meet that criteria. So we might circle back on that in the media. Could you talk to us if you had any scenarios of someone who actually did attempt to have file a lawsuit after they got out?
Yeah, so it's actually really common. People try. It's hard to find a lawyer, it really is. And that's a story in and of itself, like how difficult it can be to find lawyers that will take these kind of cases. Like, you really have to have money if you want to do that. And even then, a lot of times lawyers turn them down because they just don't find them winnable. And that's fairly well understood in America, that it's not easy to sue medical staff unless the abuses are really egregious and outside what they call the standard of care. Because really the law does say that as long as a doctor, medical staff are abiding by the standards of care of the profession with good faith, acting in good faith, then they're usually immune from any kind of prosecution. So it's only if you see really egregious and obvious abuses where you can get other psychiatrists or medical staff step in and go, I would never have done that. It's inappropriate that that was done. Then you might win a case of this kind. Otherwise, it's really hard to win these cases. But people try a lot. And one of those reasons is because I think that they're really seeking some kind of vindication and validation that this was wrong. And they instinctively feel it's wrong. And almost anyone who experiences this, many people feel that it's wrong. And when you watch it, it's hard not to feel that way. So yeah, a lot of people, this becomes their way of trying to kind of give voice to their attempt to sort of challenge what's happening in our society and what happened to them personally. So often in isolation, they'll do all this legal research and they'll put affidavits before the court and they'll represent themselves in these processes, which can sometimes last years, and it can be extremely difficult and challenging for them and emotionally trying and things like that. So I often even say to people, you need to be mindful what you're getting into here. But so it's done a lot, and I have talked with a lot of people that are right now in the midst of that process or tried it in the past. I've seen cases win within certain bounds and lots that just kind of peter out because it's hard to keep up the energy, because on the other side they have bottomless pockets really for hiring teams of lawyers and it's enormously humiliating because they do everything they can to make you look crazy, to kind of drive you crazy through this process. It's really quite brutal. Like I often say to people, I totally see where you're coming from, but I can't say I recommend it, because it may not be the best thing for you personally. Like, you have to really think a lot about dedicating the next 5 years of your life after this traumatizing experience to fighting it out and recognize how hard this is going to be. It's hard to say that to someone though too, because you're kind of like, I feel like I'm the oppressor in that moment and not just a messenger. But and I say that, like, I really understand why you might want to do this, but you gotta weigh all these other factors for how this is going to affect your life.
So I'm going to just ask a question and then see if we can pause for a moment. We might have somebody outside. When I was in the hospital in 2005, I had just come back from Wall Street presentation, so I was on the phone talking to my Wall Street crew. And they said, we want to sue the state of New Jersey for locking you up and keeping you there. And I said, no, we want to make a movie. And so when we come back in a moment, I want to just hear your response to that. I absolutely did not want to spend years in a court case. But I did say in 2005, we want to make a movie, and here we are in 2024 working on making a movie. So we'll be right back.